Hey, my name is Badass Benny, and welcome to my channel. If you're an ACE, AMAC, and sex human trafficking survivor, you're in the right place. And it won't cost you a penny to like and subscribe and to share worldwide. And please leave a comment down below on the video. Today we're going to talk about sexual harassment, guidelines on discrimination because of sex, Section 1604.11, sexual harassment in the state of California. 1. Harassment on the basis of sex is a violation of Section 703 of Title 7, unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute sexual harassment when a. submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. B. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual. Or C. Such conduct has the purpose or effect or unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Excuse me. 2. In determining whether alleged conduct constitutes sexual harassment, the Commission will look at the record as a whole and at the totality of the circumstances, such as the nature of the sexual advances and the context in which the alleged incidents occurred. The determination of the legality of a particular action will be made from the facts on a case-by-case basis. 3. Applying General Title 7 principles and employer, employment agency, joint apprenticeship committee, or labor organization, hereinafter collectively referred to as employer. It is responsible for its acts and those of its agents and supervisory employees with respect to sexual harassment, regardless of whether the specific acts complained of were authorized or even forbidden by the employer, and regardless of whether the employer knew or should have known of their occurrence. The Commission will examine the circumstances of the particular employment relationship and the job functions performed by the individual in determining whether an individual acts in either a supervisory or agency capacity. 4. With respect to conduct between fellow employees and employer, is responsible for acts of sexual harassment in the workplace where the employer, its agents, or supervisory employees knows or should have known of the conduct, unless it can show that it took immediate and appropriate corrective action. 5. An employer may also be responsible for the acts of non-employees with respect to sexual harassment of employees in the workplace where the employee, its agents, or supervisory employees knows or should have known of the conduct and fails to take immediate and appropriate action. In reviewing these cases, the Commission will consider the extent of the employer's control and any other legal responsibility which the employer may have with respect to the conduct of such non-employees. 6. Prevention is the best tool for the elimination of sexual harassment. An employer should take all steps necessary to prevent sexual harassment from occurring, such as affirmatively raising the subject, expressing strong disapproval, developing appropriate sanctions, informing employees of their right to raise and how to raise the issue of harassment under Title 7, and developing methods to sensitize all concerned. 7. Other related practices where employment opportunities or benefits are granted because of an individual's submission to the employer's sexual advances or requests for sexual favors, the employer may be held liable for unlawful sex discrimination against other persons who were qualified for but denied that employment opportunity or benefit.